Before we begin, we do have a number of questions from the, if I don't read your name and you're here and you want to submit something after the conclusion, have your packages do so, and I both sides and then make the determination. I have an application from the Gazette, WNYT, same, CBS 6, another WNYT, Post-Star, here, Union. Anyone else? All right. I'm sure you did. A lot of it's coming in, and you may not have gotten to me. I said we'll either get it from you or we'll find it. All right. But on the application media, including the Times Union, to cover today's arraignment.
No position.
All right, Mr. Teresi. Thank you. The application specs, those that are submitted, including the Times Union, which we'll get. I'm filing all of the original applications with the court clerk at this time. Mr. Premba, I do have a sealed indictment handed up by the February 2023 term of the grand jury. It is indictment number H82-2023V. Do you have an application to the court?
Yes, Your Honor. At this time, the people request that the court unseal indictment number H-82-2023V.
All right. The court is unsealing the indictment. The indictment is captioned, "The people of the state of New York against Vito E. Casanova, defendant." Mr. Casanova is present in the courtroom. Mr. Casanova, good afternoon.
Good afternoon, Your Honor.
What is your date of birth, please?
January 20th, 1998.
January 2098. And is that microphone on? Just pull it a little closer. There we go. You can remain seated, that's fine. And how old are you?
25 years old.
All right. You're here with Mr. Teresi and Mr. Shapiro. Are they your attorneys and authorized to speak for you?
They are.
All right. Mr. Teresi, good afternoon.
Good afternoon, Judge.
Mr. Shapiro, good afternoon to you.
Good afternoon.
Mr. Teresi, have you received a copy of the indictment?
Yes, I have, Your Honor. Acknowledge receipt, waive a formal reading, enter a not guilty plea with respect to each and every one of the counts.
All right. Thank you very much. Mr. Casanova, the purpose of today's proceeding, which is called an arraignment, is to advise you of your rights. You have a number of statutory and constitutional rights that flow and arise from the filing of the indictment by the grand jury. Your first, most basic and important right is your right to an attorney. Obviously, you have Mr. Teresi and Mr. Shapiro here with you today. They will represent you throughout the entirety of these proceedings. Do you understand that?
I understand.
And if at any time during this arraignment you have any questions, just let me know, and Mr. Teresi can speak to you privately, okay? All right. You also have a right to a full, public, speedy jury trial on the issue of your guilt or non-guilt. You have a right to face your accusers and the right to be faced by your accusers, and with the assistance of counsel, cross-examine witnesses the DA would call to testify against you. Do you understand that?
I understand.
You also have the right to have Mr. Premba prove beyond a reasonable doubt the allegations contained in indictment number H82-2023V. As Mr. Teresi said, he does have a copy, and you have a copy. It is an 8-count indictment. The first count is attempted murder in the second degree as a Class B violent felony in violation of sections 110 and 125.25 sub 1 of the penal law. There are a wide range of sentences the court could impose if you were convicted of that charge or if you pled guilty to that charge, but the most severe sentence is a determinate term of up to 25 years in state prison plus 2.5 to 5 years of post-release supervision. Do you understand that?
Yes, Your Honor.
The second count is assault in the first degree, a B violent felony. It similarly carries with it a determinate range of up to 25 years plus 5 years of post-release supervision. The third count is menacing in the second degree, a Class A misdemeanor in violation of section 120.14 sub 1 of the penal law. As a misdemeanor, the maximum sentence is 364 days. The fourth count, a misdemeanor, also reckless endangerment in the second degree, 364 days. The fifth count is possession of a firearm in a sensitive location as a Class E felony in violation of section 265.01 subdivision E of the penal law. As an E felony, the maximum sentence range is an indeterminate term of 1 1/3 to 4 years. With regard to the sixth count, the count of possession of a large capacity ammunition feeding device, a Class D felony in violation of Section 265.02 sub 8 of the Penal Law. As a D nonviolent felony, the maximum sentence range is 2 1/3 to 7 years. With regard to the seventh count, possession of a large capacity ammunition feeding device as a Class D felony, similarly 2 1/3 to 7 years. And the last count, the eighth count, harassment in the second degree, a violation of 15 days in the Saratoga County Jail. Given the configuration of the indictment, it may be that some of those charges would run concurrently or potentially consecutively if you were to be found guilty or to plead guilty. You are so advised. Do you understand that, sir?
Yes, Your Honor.
All right. At the conclusion of today's arraignment, you are entitled to an adjournment. The purpose of the adjournment would be for your attorney, Mr. Teresi, and Mr. Paremba to engage in discovery and inspection of the people's case. In addition, you do have a right to make a bail application or have a bail agreement. If I do set bail and you post a bail, you would be at liberty while the matter is pending. Do you understand that, sir?
Yes, Your Honor.
Mr. Teresi, is there any reason why the defendant should not answer to the indictment at this time?
No, Your Honor.
Mr. Paremba?
No, Your Honor.
Mr. Kesselnova, how do you answer to indictment number H82-2023V, the counts contained therein, the top count being attempted murder in the second degree, guilty or not guilty?
Not guilty, Your Honor.
And Mr. Teresi, as you said, you offer that not guilty plea on his behalf?
That's correct, Judge.
All right. As I indicated, we'll enter a not guilty plea for you today. I do have a scheduling order setting forth the entirety of the case dates going forward. I'm going to file the original with the clerk of the court. I have a copy for all parties, including the defendant. As you can see from the scheduling order, depending upon whether or not Mr. Kesselnova is at liberty, if he's at liberty, then the next court date will be May 2nd at 9:30 for discovery compliance, Mr. Paremba. If he is incarcerated because of a bail status, then the next court would be April 17th at 9:30. If there is a resolution or an offer that we can resolve the case, we'll attempt to do that at a conference on May 12th at 9:30. That'll be discovery compliance and then accept, reject. Prosecutor's information and response motions 526. Decision and order by the court on June 9th. Pretrial suppression hearings, if any, will be on June 23rd at 1:30. Sandoval Molino will be July 27th at 1:30, and a trial date certain will be July 31st at 9 a.m. Mr. Teresi, you acknowledge receipt of the scheduling order?
Yes, Your Honor.
Mr. Paremba?
Yes, Your Honor.
All right. I understand, Mr. Paremba, you're asking for an order of protection as part of the application for the arraignment?
Yes, Your Honor.
And Mr. Teresi, have you had an opportunity to review that?
Yes, Your Honor. I've advised my client. We've reviewed the order of protection. He signed it.
All right, if you could give it to the court officer. Thank you very much. Mr. Kesselnova, I'm going to issue this order of protection that the people are requesting. This advises you that you must have no contact with Alexander Colon, C-O-L-O-N, date of birth 12/16/94. That includes his home, school, business, place of employment, no contact, direct or indirect, including mail, phone, email, voicemail, or text message. Do you understand that, sir?
Yes, Your Honor.
All right. Defendant has signed it. Court is signing it. He is present in court. He's advised in court of the issuance and content of the order will be personally served today. We're dating it today's date. Thank you. And we'll make it in force and effect for 1 year's time throughout the duration of this case at least. All right, we'll file the original with the clerk and provide a copy to both sides. I do have the defendant's DCJS history. Mr. Paremba, do you have a... This is his only offense, is that right? No prior?
No prior history.
Okay. Do you have an agreement or a bail recommendation?
Yes, Your Honor. I have spoken with Mr. Teresi, and I let him know that I would be recommending the bail amount of $50,000 cash, or in the alternatives, $100,000 bond, or $1 million with a partially secured bond at 10%.
All right. $50,000 cash, $100,000 bail bond, $1 million partially secure bail bond with a 10% premium. Mr. Teresi, is that on agreement? Do you wish to be heard? Do you wish to argue that? What's your position?
That's on agreement, Judge.
On agreement. All right. Bail will be set in the amount of $50,000 cash, $100,000 bail bond, $1 million partially secured bail bond with a 10% premium on consent of both sides. Mr. Teresi, does your client have that bond available and posted for today?
Judge, he plans on providing proceeds related to the cash portion, so he's prepared to go into custody.
All right. So in a minute, we'll take him into custody in lieu of bail, and it's your intent to have him or someone post on his behalf at the correctional facility?
That's correct, Judge.
All right. So we'll do that. Anything further today, Mr. Teresi?
No, sir.
Anything further, Mr. Perma?
Judge, I just noticed, with respect to the trial date, I know I have a conflict. I'll write the court and Mr. Teresi about that conflict.
Yeah, any dates that you know that are not going to work for you, just let Chambers know and we'll work around everybody's schedule. Okay. Anything else?
Not for me.
All right, I'm going to remand you into the custody of the New York State court officers at this time in lieu of bail. Thank you, Mr. Teresi. Thank you, Mr. Perma. That will conclude the matter.
Thank you.
All right, we're adjourned. Thank you.